5 seconds to go. Start. Heard Mr. Siddharth Agarwal, Learned Senior Counsel, appearing for the petitioner, and Mr. S.V. Raju, Learned Additional Solicitor General, appearing for the respondent state. The petitioner is in custody in connection with FIR number 65 of 2020, dated 26 February 2020, registered at Police Station Dyalpur District, North East, Delhi, in connection with rioting and murder of one Ankit Sharma, an official of the Intelligence Bureau, Ministry of Home Affairs, Government of India. Apart from the aforesaid case, several other cases relating to riots in Delhi which took place in the month of February 2020 and one under PMLA are pending consideration, and the petitioner is allegedly involved in all of them. The petitioner so far has not been successful in getting bail in the above case and some other cases, so he applied to the High Court for grant of interim bail from 14th January 2025 to 9th February 2025 simply to participate and contest Delhi Assembly Election 2025 from Mustafabad constituency, Delhi. It may be remembered that the petitioner was earlier a councillor from the ticket of the Aam Aadmi Party. However, subsequently he left the said party and was given ticket to contest the assembly elections by the All India Majlis-e Ittihadul Muslimin AIMIM. He took the ticket to contest the assembly elections fully knowing that he is in jail in connection with several cases, in some of which he may have been granted bail but continues to languish therein, and so he has to participate in the election remaining behind the bars. The interim bail application moved by the petitioner was considered by the High Court and was ultimately disallowed by the order impugned dated 14th January 2025, but he was granted conditional custody parole for subscribing oath and to complete formalities in respect of filing his nomination papers to contest the assembly elections. In this way, though the petitioner has no fundamental right to contest the elections, but his statutory right to that effect was duly protected. The petitioner is not satisfied by the grant of custody parole for filing his nomination, enabling him to participate in the election, and has thus preferred this special leave petition contending inter alia that permitting filing of nomination is meaningless if he is not allowed to campaign and canvass. It is important to note here that right to campaign or canvass is neither a fundamental right nor a constitutional or a human right. It is not even a right recognized under any statute. However, the petitioner is an Indian citizen, and we are conscious that his rights as a citizen are to be protected. Nonetheless, the involvement of the petitioner in as many as 11 cases, including the present one pertaining to PMLA, and 9 in relation to Delhi riots of 2020, dilutes and erodes his position as a law abiding citizen. The allegations against the petitioner in the present case are not only in connection with the writing but also of the murder of the official of the Ministry of Home Affairs, Government of India. The allegations made against the petitioner, if considered cumulatively along with the charge sheet which has been submitted on 2nd June 2020, reveals the seriousness of the charges levelled against the petitioner. The allegations against the petitioner are also to the effect that his house office was being used as the epicenter for the commission of the aforesaid offences in which murder of one Ankit Sharma is a sequel. On the rooftop of petitioner's house building, objects like stones, bricks, petrol bombs, acid drums, etc. were recovered, which were used during the riots as per material on record. It has come on record in the order impugned that many material witnesses, especially in connection with the present FIR number 65 of 2020, are yet to be examined. In the aforesaid facts and circumstances, and keeping in mind the submissions of Shri Siddharth Agarwal, learned senior counsel for the petitioner, who has confined his arguments to the grant of interim bail only, as the regular bail remains pending for consideration before the High Court, the limited issue before this court is whether a purpose based interim bail can be granted to contest the election or for canvassing, as the petitioner himself is one of the candidates. There is no provision for interim bail under the law, but lately it has become an acceptable mode of grant of bail in certain special contingencies. In Arvind Kejriwal versus Directorate of Enforcement, this court quoted with approval from Athar Parvez case, which reads as under: the expression interim bail is not defined in the code. It is an innovation by legal neologism which has gained acceptance and recognition. The terms interim bail, interim suspension of sentence have been used and accepted as part of legal vocabulary and are well known expressions. The said terms are used in contradistinction and to distinguish release on regular bail during pendency of trial or appeal till final adjudication. Applications for interim suspension or bail are primarily moved and prayed for when the accused or convict is not entitled to or cannot be granted regular bail or suspension of sentence, or the application for grant of regular bail is pending consideration and is yet to be decided. Interim bail entailing temporary release can be granted under compelling circumstances and grounds, even when regular bail would not be justified. Intolerable grief and suffering in the given facts may justify temporary release even when regular bail is not warranted. Such situations are not difficult to recount, though making a catalogue would be an unnecessary exercise. The reasons and factors whereunder interim bail may be permitted may include cases where there is death in the family of the accused and the cremation has to take place to attend the wedding of son, daughter, or of any close relative of the accused, but such a right has not been recognized on the plea of contesting or canvassing for the election. In the event interim bail is made permissible on the ground of contesting elections, it will open a Pandora's box, inasmuch as in this country election in some form takes place throughout the year and the accused persons in jail may take undue benefit of it, and even if they are not serious in contesting elections, they would move interim bail application for the purposes of participating in the election, knowing fully well they are likely to lose or are not serious contenders. This will open a floodgate of litigation which ought not to be permitted, so as to widen the scope of grant of interim bail, more particularly when the regular bail application is pending consideration. Secondly, if right to participate, canvassing and contesting in election is allowed to be treated as a ground for interim bail, then the necessary sequel of the same would be that the accused person ought to be allowed to vote in the election as well. Such a sequel would be in conflict with the provision Section 62(5) of the Representation of People Act 1951, which circumscribe the right to vote by laying down that no person shall vote in any election if he is confined in a prison or is in lawful custody of the police. Stop.